Looked like we were recording.
No, now we're recording.
Oh.
Yes.
Okay. All right, it's official. So I am going to call to order the June 26th special meeting of the Fort Ord Reuse Authority Board of Directors. Let me see. Our first item of business is a closed session, I believe, but I have lost, somehow
Yes.
the agenda has disappeared.
Correct, it is a closed session.
Okay. In that case, I will ask the assembled multitude if there are any public comments on any of the items. Well, let's see. Let's first have council tell us what we're going to be discussing, and then we'll see if anyone has comments. Go ahead, council.
Unmute. Okay. Thank you, Chair. Members of the board and public. 3 items on the closed session agenda today. The first one is conference with legal counsel, Government Code Section 54956.9A D1, California Native Plant Society versus Fort Ord Reuse Authority, Monterey County Superior Court case number 20CV00159, matter of pending litigation. Item 2B, conference with legal counsel, anticipated litigation. That's based on a receipt of a notice of intent to sue from Keep Fort Ord Wild. And the third item, conference with legal counsel, anticipated litigation, based on a receipt of a claim pursuant to Government Claims Act by Resource Environmental, Inc. Those are the 3 items today on closed session.
Thank you. Is there any member of the public who would like to ask a question or make a comment on any of these closed session items? If you would raise your hand either in the Zoom way by finding the participants tab and then the raise hand function at the bottom of the list of people, that would be great. Or the old-fashioned way, if I can have my helpers help me see if there are people raising their hand that way. Seeing no hands in any format, I will close public comment and we will recess into the other room, the other Zoom room, and we'll be back in open session as soon as we can. Okay, it looked like everyone has made the journey from one room to the other. I'm going to reconvene the special meeting of the Fort Ord Reuse Authority Board of Directors. Today is Friday, June 26th, 2020. And council, could you announce any action taken in closed session?
You're on mute, John.
Unmute yourself first.
Can you hear me now? Very good. Thank you. Yes, thank you, Chair. Members of the board and public, the board met in closed session on items 2A through C. In the California Native Plant Society matter, council was given direction. There's no reportable action there. Closed session, item B, Keep Fort Ord Wild, anticipated litigation, no reportable action there. And section 2C, resource environmental case has been, there is authority to settle that case. And once it's confirmed and finalized, I will announce it out if there's another meeting at that time.
Thank you. We'll move now to announcements, acknowledgments, and correspondence. Mr. Metz.
Yes, thank you, Chair and members of the board and the Monterey Bay community. This our potentially last FORA board meeting. I'm happy to report that we have a much smaller number of correspondence to the board. Beginning June 23rd, we received a letter from Lafco regarding the transition plan. June 25th, a letter from the United Veterans Council thanking FORA staff and board for the support that was approved last week. And I believe just as this meeting began, there was another correspondence received that has been shared with the board members from Stamp Erickson Law Firm. Other than that, I'll save further acknowledgments and announcements for my executive officer's report, item 7B. Thank you.
Thank you. Now I'd like to turn the floor over to Director Garfield, please.
Thank you, Chair. So I'm going to share my screen. Oh, drat. Okay, here we go.
Yeah, get permission from Harry first. Oh, there you go.
Okay. Yeah, without Harry, nothing happens. So, Chair Parker asked me to put together a moment in time for us to stop and take stock. And so I'd like to share with you some thoughts. So here we are at FORA, and we know that right around the corner, the final curtain is upon us. And we don't know if we're going to have a sunset with sunny skies, storm clouds, tornadoes, gale force winds. We don't know. But let's take a look at what FORA looked like in December of 2019. There were a lot of contradictions. There were twists and turns. It was uncertain. We had 6 months. Things were unfinished. There was a lot of conflict and a lot of drama. And here we are in FORA's final days. We've had a shrinking staff doing way more with way less all the time, looming deadline, loose ends, sudden discoveries. Certainly there were a huge amount of surprises, both legal and otherwise, things coming out of left and right field. And I want to just stop and say, what did we get from Josh and his staff? We got solutions, we got collaboration, we got a diligent effort, we got outreach, we got possibilities, we've got calm, we've got win-wins. So with thanks to Larry Samuels, Mary Adams, John Phillips, Steve Matarazzo, Debbie Hale, and Jan Reimers for lending their words, here are some thoughts. Shaping informed decisions and gathering consensus with a large multi-jurisdictional board is really, really hard. The staff was professional, both past and present, and performed admirably with that challenging task. Josh took over a decimated FORA, took on a board that hadn't agreed to anything in a decade, and his adept management acuity brought together diverse and competing views and overcame insurmountable hurdles. So much has been accomplished. We should stop and remember. CSUMB, the Dunes, East Garrison, Veterans Cemetery and Clinic, miles of open space and trails, and more. So remember, Josh took up the rail, sorry, my mortgage broker is calling. Josh took up the reins at a pivotal time and has carried out FORA's last days in an impressive way. His calm demeanor and knowledge of FORA has proven to be an asset. The whole crew has demonstrated unending optimism, tireless energy, courage, and good faith. Finalizing a bond for building removal is of tremendous importance to the continued economic development of the region and every jurisdiction. Successfully and smoothly transferring expertise, funding, and continuity for ESCO Seaside is of great value for now and the future. So somehow, the impossible became possible. We owe Josh, the leader of FORA needed, and his staff a deep debt of gratitude, with many thanks to the whole talented team for their hard work. I want to take a minute to call out some kudos. Jen Simon served as an entire IT department, HR department, chief listener, major problem solver, graphic designer, and webmaster. Helen Rodriguez was the financial kingpin. She tracked it, she reported it, she predicted it, she presented it. So decades of operations could be wrapped up. Every day she demonstrated respect for every person in every interaction, and she's a dynamite baker. Erlinda Flores, we don't get to see much of, but she handled all the contracts, that tremendous flow of information and paper that need to be finalized so that when the lights go out, there's just not still paper floating around. She stepped up starting as a temp and is on track to finishing an MBA. Stan Cook and Laura Vidari, who are now Seaside staff, had the oversight and management of a key responsibility that really truly made everyone safe. Stan's the longest serving FORA staff member. He's seen it all, he's made it work. Laura was the best face of FORA in the community. She put our best face forward. John Giffen never lost his cool, always had an explanation to help our understanding. He led the legal team through the forest, the swamps, the front line, and the courtroom. Harrison Tregenza, who I call the king of battlefield promotions. He stepped up in gap after gap. He brought expertise and professionalism to every task. Without Harry, there is no Zoom. Without the Zoom, there is no work. And with quiet competence, he's a great frontline presence in the midst of chaos and unending change. David Willoughby was mightily quietly fixing things. He clarified complex, contentious issues. He is a master of writing and thinking, listening and understanding. Our agreements, understandings, and contracts have all been better for his efforts. Christy Reimer goes back before there was a FORA and has put a bow on these projects so that the handoffs are clean to the jurisdictions, and that will matter now and for a very long time. Erin Harwain and the Denise Duffy team have deep roots in FORA. And thanks to Erin, we can negotiate the complexities and mysteries of CEQA and come out with reasonable solutions. And finally, Kendall and Steve Flint took on tasks that no one else was brave enough to take on. They have dedication, laser vision, and a capacity to handle a stunning amount of information. They walked into the line of fire. They are shuttle diplomats, and they balanced competing perspectives to get us to the final transition. But every one of these feats was made possible by years of contributions from FORA staff that are no longer with us. We offer them thanks as well. And because I made the PowerPoint, I get to say thank you to all of the member boards, the ex officios, and the people like Ron Cheshire who have stood by and been a good voice for everything. Your presence, personalities, contributions, and participation really mattered. I learned lessons, examples to follow, and I saw unending dedication to doing serious work that needed to be done. It's been a hell of a ride. Take care of yourselves. So now we have a video message from Congressman Panetta, who's been part of this in many ways, and then back to you, Madam Chair.
Can everyone see my screen?
Yes.
All right, let me know if the sound works. Hopefully it does.
Hello, everyone. I want to take this time to recognize Josh Metz and his staff for their dedication and service on the Fort Ord Reuse Authority. The implementation of FORA and its related mandates have been challenging, to say the least. But fortunately, Josh and his team, and yes, even those who came before him, have always met those challenges in order to serve our communities and go forward. Boy, are we grateful, boy, are we thankful for his leadership, the long hours, and of course, the hard work by him and his team to accomplish our shared goals for Fort Ord and our future. Thanks, Josh.
Nice.
All right, back to you.
Nice. Thank you. Thank you, Cynthia. Thank you, Director Garfield, for putting that together. And I do think that if any board members would like to say a sentence or two, I mean, we have a bunch of work before us, but I think it's appropriate to take a little time to recognize the folks who have been laboring in the vineyard certainly these last few months, but also in the years prior. So if board members would like to say something, please raise your hand in the Zoom area, and I will call on you in the order that the hands appeared. And then I will risk also opening up to the public, because I think people from the public who are here are also those who have attended to Fort Ord business in a very dedicated way and may have a couple of thoughts to share. And we'll keep the public comment to a minute each. So with that, Director Hoffa and then Director Reimers, please.
Josh, you did a great job. You got us to the finish line. It wasn't easy, but you did a great job. I appreciate that you listened to me as an individual director, to the whole board, and to members of the public, and that you gave us alternatives and helped us get here with as little, as few things unresolved as were feasible. So you did a great job. Thank you.
Thank you.
Director Ramers and then Director Wizard.
I too want to thank all of the staff, and I can't say it any better than Cynthia said it, how much we appreciate your dedication and your guidance and all that you've done. I have to say that when I came on board 4 years ago, I was very ill-informed about Fort Ord Reuse Authority, and the entire staff was absolutely wonderful. Stan Cook took me on tours, so did Michael Hulamard, helped me understand the vast property that I was now going to be a part of fostering and working. And we really, I think, have accomplished a great deal because of the leadership from all of you, and the development that you worked on before moving into the position you're now in has really paid off and continues to continue to pay off. So I think we can be very proud, and it's been a learning experience and something I still am very proud of, all of the accomplishments and the challenges. So thank you, and thank you to all the staff who worked for so many years.
Thank you. Director Wizard and then Director Samuels.
Thank you, Madam Chair. And you're going to hear a lot of good things, Josh, but I'll just try to be succinct and say that you stuck the landing. You know, we didn't give you a lot of runway, and we all safely landed here. We've got the properties that are being transferred. We've got the LRA in place so that the legacy continues, and everything that was promised from the beginning about reusing the land and getting the university and all that stuff, you know, we made good on those promises. I'm late to the game here as a relatively new member, but the limited time I had, things went pretty smoothly, and that has to do with a very successful transition from Michael into your hands. So great work, and thanks for all your work.
Thank you. Director Samuels and then Director Phillips.
Thank you, Madam Chair. I'd like to address this to the entire FORA team, present and past, from the entire CSUMB team, present and past. Our trajectory was tied together all the way through. FORA has always been very stand-up and very protective of the interests of the university, as have the members of this board, and it is deeply, deeply appreciated. The efforts over the last 6 months on the part of the entire FORA team have been exemplary, and it is noted and appreciated.
Thank you. Director Phillips and then Director Berkeley.
Just briefly, my comments were a part of Cynthia's that she put in, but I was super impressed with the work that Josh did as economic developer here, and made progress that none of us had seen in years. And so it was a great transition when he took this over. And at that time, most of us thought, we got 6 months to get to the finish line, we'll never be able to do it. He, and especially with a staff of, putting together a staff of people that knew they were working themselves out of a job is difficult. We really appreciate all the staff that you've done and all the work that Josh has done. So thank you for getting us where we are.
All right.
Thank you. Director Berkeley and then Director Adams.
I very much echo what has been said so far, and I know certainly on behalf of the city of Marina, sometimes we push a little bit more to try and make a really fair closure here, and everyone has handled this with such grace. And so thank you, Josh and the team. You've really done fabulous work guiding us. Thank you.
Thank you. Director Adams and then Director Oglesby.
I've said it a number of times, but thank you so much. The courage that it took for you to stand up, and your unbelievable optimism as we have moved forward, coupled with your sense of humor and your grace, is really wonderful. I so thank you. I think the last thing I want to say to all of my colleagues, but especially to you, talk is cheap. Let's find you a job.
All right. We like.
All right. right. Thank you. Director Oglesby.
I guess I have to say the same thing. Let's find him a job somewhere at the county paying big money. Right? Got the majority sitting up there somewhere. But I would say that, you know, I said my kind words to Josh yesterday at the closeout of the Veterans Affairs Committee. And what I told him was that he jumped in right after Michael and he picked up the reins like other people said before, like we couldn't imagine, and got us to this point. So his name will go down in the history book just next to Michael Hulamar's, because what he has done in the last 6 months is just remarkable, keeping us together, keeping us focused. And I think we have more meetings in the last 4 or 5 months than we had all over the last 2 years. But that's the team he put together, and they were working themselves out of a job, and we appreciate that because we were crossing our fingers all along to make sure that they didn't get another job, because we know we needed you. So we appreciate you guys staying fast. And yeah, so just thank Josh and the whole team. I really appreciate you guys. But I want to say to the whole FORA board, I appreciate working with all of you and your predecessors. I won't take the moniker that we didn't accomplish enough. We accomplished what we were supposed to accomplish. Could we have done more? Yes, but we are individual people and we made the decisions that we made. And I learned so much from you guys, arguing with you, debating with you. And I just want you to know how much I respect all of you as individuals and elected people, elected individuals, and your predecessors. So I just want to thank you guys so much, and I will see you around in other venues. And especially the chair, we know it's hard for her to wrangle us in the last 6 months. And I think, again, not only the FORA meetings, but we also had the Habitat meetings, executive meetings, and other meetings that she had to attend to get forward to this day. So I thank the chair and I thank the rest of the board.
Thank you. Thank you, Mr. Mayor. I don't see any other hands of board members at this point. Anyone else from the board, ex officio, is fine, who wants to say anything at this point. I will go ahead and open it to the public. And I know that the public sometimes likes to raise their blue Zoom hands, but sometimes they like to raise their actual human hands. So I will be looking for those as well. Anyone want to say anything at this point? Mr. Cheshire, you have 1 minute, so, you know, use those words wisely.
You're on mute, Ron.
Yes, let me unmute there. Yes, thank you. Josh and staff, you're crossing the finish line. That remains to be seen with this single vote left. And you guys have done a fantastic job. Now you know what us construction workers feel like to basically work themselves out of a job, every job they ever get. So you're all well qualified, and I wish you the best of luck and hope that the jurisdictions are smart enough to recognize your talent and provide an opening in spite of what we're facing at these times. And thank you.
Thank you.
Thank you, Ron. Doug Yount has his hand up. Please go ahead.
Thank you, Madam Chair. This is Doug Yount on behalf of Marina Community Partners, and prior to that, when I was in the city and other things, known Josh for a while. I would echo the comments that have been made. Real leadership is what happens when you get thrown into the the swamp with the alligators right away after the without any prior planning. And I just want to commend Josh for all of that effort. Also, Harry, I have to say that's pretty amazing to be able to just jump right in there. I don't know if this is your first position or career, but I'd have to say you've done a great job getting thrown to the wolves there as well. And I just want to also just take a moment to thank the FORA board for all of the effort and energy and work that you have done all over these years. I just applaud the amount of hours and effort that you've done to try to come together and redevelop former Fort Ord, which is a very difficult task. And I think everyone needs to be commended for that effort.
Great, thank you so much. Any other members of the public wanting to say a few words at this point? I'm not seeing any other hands. Any of my helpers see hands I might be missing? Okay, great. I will bring it back to the board, and I think we've heard a lot of good things. I want to just take the opportunity, Josh, we have made a, let's see if I can get this to show. It's a, I don't know, it's not really a plaque. It's a thing with, it's clear, it has your name and some nice words on one side, and then it has a picture from the former Fort Ord, and it's just a recognition of you and your staff. We know that these things don't happen by themselves and by only one person. So just to put a little icing on the cake that has been baked here today, just wanted to thank you so much for your leadership. I worked with you on the PRAC, and so I was very supportive of you taking on this very difficult final role here. And I think you've just, your ability to include many disparate viewpoints and treat people with respect and focus on facilitating solutions. And you really made it clear from the beginning of your tenure that you weren't going to be able to fix everything, that it was really up to the jurisdictions to work it out. And and that's the kind of reminder and leadership that we needed at this point. And it's taken still a lot of work on your part, but you also put us to work, which was great and much appreciated. So I don't know if, do you want to save your comments until the executive director's report?
Yeah, I'll do that. I just, of course, many thanks for all of those kind words. It could not have happened without all of the folks that were mentioned in Cynthia's nice summary there. And I will do a little bit more at the executive officer's report. It's humbling, much appreciated. And let's see if we can get through this agenda, and then we'll do a little more after that. Thank you.
Great. Thank you. Thank you, Mr. Metz. Now we will call the roll and see who's here. Mr. Tregenza, would you call the roll?
Supervisor Jane Parker.
Here.
Supervisor John Phillips.
Here.
Supervisor Mary Adams.
Here.
Councilmember John Gagliotti.
Was here. He's here up in the corner, but.
Yeah, I mean, I double muted. I'm here.
Thank you. Councilmember Frank O'Connell.
Here.
Councilmember Lisa Berkeley.
Here.
Mayor Ian Oglesby.
Here.
Councilmember John Wizard.
Here.
Mayor Marianne Carbone. She told me she'd be in and out. She's driving, so hopefully she makes it. Mayor Joe Gunter. Councilmember Cynthia Garfield.
Here.
Councilmember Janet Reimers.
Here.
Katie Moon.
Here.
Colleen Courtney.
Here.
Erica Parker. Mike Zeller. Dr. P.K. Diffenbaugh. Steve Matarazzo.
Here.
Dr. Lawrence Samuels.
Here.
Colonel Gregory Ford.
Here.
Bill Collins. David Martin.
Here.
Lisa Reinheimer. And Jan Schreiner. We have a quorum.
Thank you. Thank you. Our next agenda item is the consent calendar, and on it we have a number of sets of meeting minutes. Somebody was burning the midnight oil, so thank you for those. Director Hoffa, I see your hand up.
Yeah,
Did you
just
want
for
to
the
pull?
record- Just for the record, I wanted to announce I am here. Thank you.
Oh, thank you. Thank you for doing that. Is there any board member who would like to pull any of the consent calendar items for a question or comment? Seeing none, are there any members of the public who would like to pull any of the consent items for a question or comment? Seeing none, I'll bring it back to this board. I'd entertain a motion to approve the minutes or approve the consent calendar.
Consent agenda.
Thank you. Motion by Hoffa.
Second by Phillips.
Second by Phillips. Thank you. Any discussion? Okay. Mr. Tregenza, would you call the roll for the vote?
Supervisor Jane Parker,
Aye.
Supervisor John Phillips,
Aye.
Supervisor Mary Adams,
Aye.
Councilmember John Gagliotti,
Aye.
Councilmember Frank O'Connell,
Yes.
Councilmember Lisa Berkeley,
Yes.
Councilmember Alan Hoffa, Councilmember Alan Hoffa, you're muted.
I heard him say aye, but your sound's a little off, Alan, just for the record.
Mayor Ian Oglesby,
Aye.
Councilmember John Wizard,
Aye.
Mayor Marianne Carbone, Councilmember Cynthia Garfield,
Aye.
and Councilmember Janet Reimers.
Aye.
Motion passes unanimously.
Okay, good start. All right, we'll move to our business items. First one is 7A, and this is a transition plan update. And I think this is, well, it's an update.
So this will be led by your trusted strategy and transition consultant, Kendall Flint, and well supported by Mr. David Willoughby. And I can just say that this item has continued to receive input from the community up until even the start of the meeting. So it remains an item of concern and focus for people. I'm hopeful that what's presented is sufficient and will allow clarifying of the 2018 transition plan to account for what has occurred, and will set forth a clean path forward that will allow us to conclude this item with a unanimous vote. But if not, we do have a placeholder for Monday. So with that, I would pass the mic over to Kendall to lead us through the item. Thank you.
Thank you, Josh. And just as a note for all, I think that the FORA countdown calendar has us at just under 4 days till sunset. So something I learned when I was in college, you have as much time as you have until the paper's due. The paper is now due. So it's going to be today or it's going to be next week, but we are going to get through this. Just as a reminder, we have been looking at this transition plan quite closely over the last 6 months. And as a reminder, we had other meetings in March, April, and May, at which time we presented different options for the board for your consideration. The majority of things that we've done in this plan at this point is basically change it to update current board policy, things like the way that you successfully allocated the habitat conservation funds, the way that we've offloaded some of these CIP projects, a number of other pieces. Now, at our last board meeting, we talked about some of the things that have been accomplished just in the last few weeks, which is recording the master resolution, updating on the CalPERS liability and how we're going to pay for that. And all of that information now is reflected in this document. It also includes, of course, the idea that the city of Seaside has now taken over as the LRA and EDC, which is a tremendous accomplishment that really shows a lot of collaboration between all of our member agencies. Now, what we heard at the last meeting, of course, we wanted to include prevailing wage. So that is absolutely in both of the versions. And it also removed, of course, items that were not completed by FORA or its member agencies by next week. What we heard at the last meeting from the board was an overall consensus for continuing with, again, prevailing wage. And I would say the majority of the things that we walked through. And what we were asked to do is come back with two versions, one that included Lafco as a successor in those three sections you may remember, and one that basically said, no, the local land use will go elsewhere. I want to kind of set this up so that everybody understands kind of why that worked out in this particular way. We did hear from Lafco early on that they wanted some closure on some of these things. And so the folks at CAGLA basically looked at that, and that was one alternative they came up with, which we did discuss at the last meeting, and we look forward to discussing further today. The other idea here is that we would not name Lafco specifically in those three sections, and that'll also be up for discussion today. Additional comments were received from Marina and Seaside to sections 2.2.1, 2.2.8, and item 4. And I'm going to bring those up so you can see what the suggested changes were. I'm going to stop my share for just a second so I can get the right document. Let's see here. Give me just a moment. As we were making changes on the fly today, you know how that goes. Here we go. So I think you should be able to see my screen, but let me know if you cannot. This changed 4 sections. One related to 2.2.1, which basically clarified unpledged property tax revenue. One section in late discovered items, and then one section that related to one of the iterations in numeral 4. David, would you mind explaining what the impact of those changes are to the board?
They serve to clarify that in paying late discovered items or other responsibilities of FORA, that the future tax increment would be the last source of revenue looked to, and it would only be the unpledged portion of that future property tax increment. The part that's necessary to support payment of the bonds would have priority over the kind of last ditch source of revenue to pay otherwise unsatisfied FORA liabilities that exist after FORA's dissolution. So these suggested additions of the word unpledged in these several sections are, I think, a clarifying change that would be applicable under any of the variations on the transition plan that will be considered by the board today.
Thank you, David. I think the other thing that I wanted to mention is really our thanks, both staff and of course the David and myself have worked very closely with Sherry Damon at the City of Seaside, with Wendy Strimling, who's been really very helpful with her comments from the county, as well as the City of Marina and others. We do appreciate, however challenging this has been, it needed to be a collaborative effort. And I think the document we have before the board today really reflects what the guidance has been over the last 6 months. And I would like to add my kudos to Josh and to Jen and to the entire FORA team for helping us see this through to this point. And with the chair's discretion, I can either go through each of the alternative documents line by line as we've done before, or we can open it up to discussion at this point. I think the fundamental question that we have as staff is basically, do we want to have the agreement include Lafco in the sections that were discussed previously, or do we want to remove that and have those responsibilities fall to the underlying jurisdictions? I believe there was also some comments and questions that have been raised by board members in the last couple of days relating to this. So I think fundamentally that's where we're at in terms of the discussion for today, is in terms of which version or a third option might be the pleasure of the board.
Kendall, before we get there, there was a second slide that involved section 2.2.8 that resulted from, you might want to show that as additional suggested changes. and they also, I believe, are helpful, clarifying, and should be included in any of the possible versions that the board might adopt today.
Yeah, and David, I don't know if you could see the screen, but that was the section that I had up just a moment ago. So the changes would be universal to anything at this point is our recommendation.
There is a second document that contains only section 2.2.8, and it contains more specific references to the bond indenture language. It was the one that I sent out, I don't know, 45 minutes or an hour before the one you just projected.
Okay, I'll go pull that up right now.
You know, it's you know, helpful suggestions sometimes arrive shortly before the meeting, and it's a challenge to get them all addressed in a way that the board can see them and digest them clearly. It's particularly this slide would be difficult to walk through just verbally.
So is that the correct here? This is the one I have from you at 132.
No, it would be an earlier one than that. And if you don't mind my hopping on to a different screen here, I'll try and find the transmittal time for you.
Thank you.
Would it be possible for you all to send the board a copy of the document you're working on so that we can really get involved with it and see what we're talking about?
Yes, as soon as I get the document from David, I'll send that out to everyone. But the two documents that we are discussing were provided in the board package, and they have been available both online and were sent to the board yesterday.
Right, I have those, but you just made reference to documents that were sent out at 1:30. I believe it was today, you said?
Yeah, he's going to send me or resend me what he's discussing right now. Those were literally, we received them while board meetings were going on. So as soon as I get that from David, I'll send that over to Harry and he can send that wide.
That would be fabulous. Thank you.
Okay, and Kendall, I'm about to send you another copy of it.
Thank you, David.
All I would offer here is unusual circumstances at the end of our journey. So patience is certainly appreciated, and we'll be doing everything we can to get it out and for your consideration today.
Absolutely. Thank you for all the hard work you've put on.
David, when you send it to me, would you please copy Harry so he can in turn send that out to all the board members?
Okay, I will. I just send it to you. I will forward a copy of it to Harry. So.
Okay, I just got it. So let me call it up here. Oh, here we go. Yep. Give me just a second. All right. Can everybody see that okay? This is the update to section 2.2.8. And it's the section in red, correct?
Correct. These suggestions with regard to section 2.2.8 came from two different sources at two different times. The first to be received is the one that's showing now, and it's, in my mind, perhaps even a little more comprehensive than the second suggestion, which you've previously shown to the board. So although both I think are helpful, I would prefer the version that's up on the screen now.
So David, are you saying, so the previous thing we saw was adding the word unpledged
Right.
to the language that's struck out here, but you're saying that this longer.
Right, I think the unpledged concept is captured in the last clause of the newly added material, which says which funds are not needed for the purposes of the indenture. That's Great. Essentially the equivalent of unpledged.
Great, thank you. So we're so the word unpledged that showed up in the other couple of places, it remains, but this is just another way of more clearly and thoroughly stating the unpledged plus yes. Other.
To put it in different words, if you were to go with the version that's on the screen now, that takes care of the concept of the unpledged word that would not actually appear in this section. But I still think that the addition of the word unpledged to the the two other places identified, which was section, I think, 2.1.1 and item 4 under the resolution. I think that remains helpful and should be done. So I'm kind of recommending adoption of both of these late arriving suggestions.
Great, thank you. So these seem to be in the nature of clarifying, but as I think Kendall just said, the issue before us is kind of that liability language, right? Whether we assign it to Lafco, whether it gets assigned to the underlying jurisdictions, or whether, in my mind, we can just say we're not creating obligations for anybody. So okay, so with that, then is the board comfortable with proceeding with the discussion, or would you like to have it? Maybe Kendall, it would be helpful if you would walk through the two sample, the proposed sample language, not going through every single provision, but maybe just showing the language that would have Lafco be responsible for anything unknown, and the language that the other language that was proposed in the other version.
Yeah, and actually, I'm going to defer to David on that because he knows the sections better. There are 3 sections where Lafco is specifically referenced within the document. Right. And one of them is in section 1.2, right?
It might be helpful to skip past the 2 clean drafts that are the first attachments and focus either on attachment C or D.
Okay.
That hones in on the.
Either one is fine. They both have colors, so you can see it. You don't.
I suggest we use attachment C for this discussion.
Yes. Okay.
So you could put that on the screen, and we can just scroll to the red line portions of attachment C. To
I'm on. This is attachment C here, so I've got this one up. Let me go back to the top. Okay.
I think you'll find the first difference in section 1.5, but I haven't really memorized this.
You've been doing nothing but this all week with me. Come on. Here we go. FORA's records.
Okay, so the text that is shown in red with strike through is text that would be removed, and the text that is shown in red with underlining is text that would be added. This illustrates the difference between the version that would assign so-called catch-all responsibility to Lafco and the modifications that Lafco requested, deleting these delegations to Lafco and substituting delegations to the applicable member jurisdictions. So 1.5 is one of the places that those changes show up. I think 2.2.8 is another spot.
2.1.6, right? 2.8, late discovered. Here we are.
2.2.8, 3.1, and then item 4 at the end of the resolution. And perhaps you can scroll back to each of those 4 spots to allow us to discuss them more specifically.
Okay, so I'm going to go back up to the first one,
which was 1.5.
That's up there right now.
Okay, this has to do with the transfer of FORA's records. The proposal that was before the board at the last meeting provided that with respect to litigation dealing with alleged improprieties by FORA or failure to comply with public records requirements, that Lafco would be the responsible successor agency to defend that litigation and would handle issues pertaining to Public Records Act issues for the period prior to FORA's dissolution. Other parts of this section provide for the transfer in general of the records to the County of Monterey with a couple of specific exceptions, and that the County of Monterey would be responsible for dealing with Public Record Act issues from the point of FORA's dissolution forward. So the difference between the two versions that are attached is attachments A and B is one provides for Lafco to deal with pre-dissolution Public Records Act issues, and the other provides for the applicable member jurisdictions to deal with those pre-dissolution public record issues. So I think we can move to 2.2.8.
And it's there?
Okay, this talks about the order in which funds would be applied to satisfying late discovered liabilities or obligations of FORA. As proposed at the last meeting, the order of priority would be that the county would first use the monies left over in FORA's accounts at the time of its dissolution. The next source of money would be through Lafco applying then unexpended funds that remained in the litigation reserve monies that FORA transferred to Lafco. And then if there still remain unsatisfied liabilities, that future property tax increment revenues would be encumbered and expended under the applicable health and safety code section. Lafco has requested that the reference to using funds from the litigation reserve be removed. And if that change was made, then the order of priority would be the county first applying monies left over in FORA's accounts, and then next encumbering future property tax revenues. The next point was 3.1. And this deals with what we've kind of colloquially or informally called the catch-all provision. In the sentence that's immediately above the red text here, we've said that we're not aware of any remaining obligations that aren't addressed in the transition plan. The next paragraph with the red text in it addresses the possibility that there might be something that comes up that we weren't aware of as FORA dissolved. The original proposal before the board last meeting was for FORA or for Lafco to take responsibility for that using the $500,000 in litigation reserve funds that was provided to FORA. Lafco's request was that that provision be removed and instead provide for each of the member jurisdictions to bear joint responsibility for any unexpected or unknown obligation that arises, and that there is not enough money in FORA's accounts to pay for. And then finally, 4 is just really a technical thing. In the original version where we were recommending that catch-all responsibility go to Lafco, this provision was intended to say, even though we've made that delegation, we're not intending to try to obligate Lafco's general funds. If the changes requested by Lafco are accepted by the board, then there's no longer a need for Lafco to have that kind of protection because they won't be expending funds anyway. But essentially, those are the differences between attachment A and attachment B. Attachment A being the original proposal to assign catch-all responsibility to Lafco, and attachment B being an iteration of what we understand Lafco's request to be, and that is make that assignment of catch-all responsibility to the FORA member jurisdictions.
Great, thank you. I think that's helpful. So we're clear on what we're talking about that are the meatier issues here. So I'm going to go ahead and open it up to any board questions. I see that Director Hoffa has his hand up. Please go ahead.
Thank you, Madam Chair. Can you hear me okay? Okay. So to our legal staff, I got, I think, 2 questions. So from our last meeting, I understood that the FORA Dissolution Act basically identified Lafco as the successor agency. So in option B, if we were to elect option B, would we open up, ironically, our successors to challenge about this document not being legally compatible? That's my first question, and I have a second question that I'll hold off to hear the answer.
That understanding is slightly different than what my understanding of the Lafco Act provides. In a nutshell, the dissolution section of the FORA Act, misreferred to it as the Lafco Act, but the FORA Act provides that FORA is charged with the responsibility of developing a transition plan that assigns liabilities and assets and designates responsible successor agencies. It then goes on to provide that Lafco is to assure an orderly dissolution of FORA by seeing that its contractual commitments, and I apologize for not having the exact language at hand, but basically Lafco is supposed to carry out the transition plan to the best of its abilities. It doesn't actually say that Lafco is a successor. The Act says that the transition plan is supposed to identify who the successors are.
Okay, that's helpful. So in essence, the reason why we're faced with an option A or an option B is because we need to make somebody responsible for all of the post-FORA responsibilities. So you're trying to do that. It's either, you know, we can do Lafco or we can make the jurisdictions. So I guess then my follow-up question is, what kind of liability could this create for the individual agencies under option B?
Under option B, if there was not enough money left in FORA's accounts to satisfy obligations that remain after FORA's dissolution, and if for some reason the application of future property tax increment wasn't going to be sufficient to deal with the matter either, the responsibility would fall to the member jurisdictions. Now, to the extent that the dispute or issue relates to land use, that responsibility would only go to the land use jurisdiction or jurisdictions in which the land that was subject to the controversy is located. The other issue, besides one that's purely monetary, is if there was some action that involved a need for non-monetary relief, that would fall to the member jurisdictions. And depending on the nature of the specific action, it might be all of the member jurisdictions. You know, perhaps something like a Public Records Act dispute might not relate to any specific parcel of land, and therefore could maybe become the responsibility of all of the jurisdictions. Or if the non-monetary dispute involved really only 1 or 2 jurisdictions, it would logically fall to those jurisdictions. Does that make sense?
Thank you.
Director O'Connell.
Thank you. Looking at 1.5 that you had up, David, could you pull that up for me again, please?
I'll need for Kendall to handle that for me, but
okay, thank you.
She's getting to 1.5.
It's up.
Great, thank you. I did have a question. It relates to the records of the attorney-client privilege and attorney work product going to be held by the law firm. My understanding is all other documents would be going to the county. What is the authority for having the public records or records from a public agency being held by the law firm when the public agency does not exist? And secondly, does that anyhow jeopardize a public records request that may be made by Marina, Seaside, or an individual as to those documents? Are we then looking at litigation to determine if they are attorney-client privilege communications?
Well, let me start by explaining how we ended up here. The difficulty in turning attorney-client privileged communications over to any single entity is that there may be aspects of those communications that should be shielded from that particular entity's eyes. A second and maybe more practical difficulty is these are records that, frankly, I don't think any of the entities want to take or want to take the responsibility for or to handle as matter of future Public Records Act requests. We've had discussions about transferring, the specific ESCA and other documents to Seaside. That's been arranged. The general transfer of documents to the county as future custodian has also been arranged, but frankly, the county didn't want to take the attorney-client privileged stuff and have to sort through the thorny issues there. One idea that occurred to me after this section was drafted is perhaps Lafco could be made the custodian of these records, but I would not want to predict Lafco's reaction to that. I could well understand how they would not want to do that, at least without being compensated for what they predict to be the costs of having to administer future Records Act requests. So they more or less ended up in the lap of the law firm because others didn't want to take them or were assumed would not want to take them.
Okay, and thank you. And secondly, whether it be A or B, what would be the harm in deleting the very last sentence of 1.5 that starts off "FORA hereby designates"? Deleting that entire sentence. Marina has problems with member jurisdiction reference, and I assume Lafco has problems with the other side. So what would be the harm of just deleting it?
Unmute.
The harm would be that you would not have fully and completely addressed the call of the FORA Act's dissolution provision requiring assignment of responsibilities to successor agencies. However, I might point out that if a gap was left in the designation of responsible successor agencies, the FORA Act doesn't provide any remedy for that. FORA isn't going to be around in another 4 days. It may be a minor failing for which there is no particular consequence.
That's an interesting answer. Thank you.
Thank you. Director Phillips and then Director Berkeley.
Yeah, that was kind of my feeling too, that, by putting something in like this, we're setting someone up for encouraging liability, whether it's Lafco, which is their concern, or individual agencies. And as far as I'm concerned, after everything we've done, including today, we've taken care of all our obligations, and the fact that we just assume that there's going to be some litigation coming down the road, I don't know. I think we ought to either just eliminate that language and not anticipate any litigation we don't know about now, or and I certainly don't encourage that we modify it to say that the underlying jurisdictions are responsible, but modify it in some way. I know I talked to Wendy Stremlin about how we brace it with Lafco, saying that their responsibility is somewhat limited to finding the right entity should litigation occur, but at least limiting the language so that we're not encouraging litigation.
Director Berkeley, and just a second, Mr. Willoughby, you had a response to that?
In anticipation that there might be a desire to simply eliminate the language and make no specific designation to anybody, I prepared a third option, which would essentially do that. I don't want to, disjoint the discussion that the board's going on, but be aware, if that's a notion you would like to entertain, we have a document that we can put up on the screen. We also have a comparison document, but it really would show you that the changes proposed in sections 1.5, 2.2.8, 3.1, and item 4 of the resolution would essentially be taken out. The language that Lafco wanted deleted would be gone. The substitute language calling for these responsibilities to be assigned to the member jurisdictions would also be gone, and the transition plan would simply be silent as to those members.
Thank you. Director Berkeley?
So that may answer where I was going here, which was following up on section 1.5, also on section 2.2.8, which there were some significant changes made to. I think it's actually, if you could put that up on the screen. Just to be sure that I'm tracking this correctly. So great. I think it's like the third. Can you scroll down or up a little bit just so we can see the beginning of 2.28?
Yeah.
Great. Oh, okay. Thank you. Yeah. Correct. So when you're talking about the possibility of having it removed, the responsibility being transferred to the land jurisdictions, not only in 1.5, but also in 2.28, and I think there may be other references in the document. So you would remove it from all sections, correct?
Actually, my understanding is that only the text that is shown in red on 2.2.8 would be removed. The provision a little higher up in the section that says if there's a dispute that's specifically related to a piece of land, that would be taken over and become the responsibility of the land use jurisdiction in which the land was located. My understanding is that would remain in the transition plan.
I see.
But it's the board's pleasure.
Right. I think certainly for the city of Marina, because we're talking about late discovered items or unknown obligations, that this should also be removed as well. So that was the main concern. And then there may be other places in the document. I just am looking for consistency and to be sure that none of the cities are going to be held accountable for something which was a FORA responsibility. Thank you.
I think those are the 1.5 and the 3.1 are the sections that are of most concern from that perspective. Director Hoffa.
Thank you.
You're on mute.
Mr. Willoughby, thank you. With respect to option C, if some party out there decided that there was a responsibility that hadn't been clearly transferred in this document and they wanted to hold somebody responsible for it, if this document is silent on that count, could they potentially sue Lafco and the jurisdiction or jurisdictions
In other words, would taking no action potentially open the door for kind of wider for possible liability? Or essentially would it be a sound defense to say, look, we're not responsible. There's no document. The transition document is silent on this. How can you hold us responsible? Which of those would be the stronger argument, I guess?
Well, I can foresee several possibilities. One of them is that a future plaintiff could sue a single jurisdiction, and that jurisdiction could then try to obtain contribution from other former members of FORA. Another possibility is the one you suggested, that a future plaintiff sues Lafco and potentially includes one or more of the member jurisdictions, or Lafco then seeks to obtain contribution from the former members of FORA. There are probably a wide variety of other possibilities. The theory that a plaintiff or even Lafco might assert is that the FORA Act in its dissolution provisions calls for the transition plan to make assignments of liabilities and designate successor entities. And as I've mentioned in previous meetings, the statute is not a model of clarity. A possible defense could be asserted that although the statute says FORA is supposed to make assignments and designate successors, it doesn't say that they must designate successors for every possible eventuality. A plaintiff might argue the opposite. Bottom line is, without any guidance from the transition plan, it's going to be up to a future court to try and unravel things.
So, Mr. Willoughby, is your third option just to eliminate the sentence altogether, or would it be helpful to have language that says, notwithstanding anything else, it's the intent that no member jurisdiction shall be responsible for stuff that happened when FORA was in existence? Could you have some sort of language that says, we don't think there are any obligations, and nobody, it's not our intention to saddle anybody with that responsibility or liability? Does it make sense to have language like that in there, or just to remain silent?
Well, we've got half of that concept addressed in the language that's above the red and what's shown on the screen, and that is we've identified everything we know about. We don't think there's anything else. I'm a little troubled by the concept of trying to say, and it's our intent that no member have any potential future liability. It's one thing to look at the statute and make an interpretation that says, okay, we need to designate successors, but perhaps not successors for unrealistic or unforeseen circumstances.
Mm-hmm.
I think it's a different thing to almost contradict the statute by saying there are no successors. That's what gives me a little pause about taking that approach.
I see.
Although, I mean, I like the outcome, but I think it's important to reconcile with what the statute provides.
Thank you. Director Oglesby.
Thank the chair. I would just say that, as we close out, and I think someone said we have 4 days, and I think 2 of them we won't be here. So sometime on Monday, really, at the latest. And so to close this thing down, and when we're talking about the land use jurisdictions, we're talking about, I don't know, if there's 5 entities out of 13 positions on the board. And, if the board cannot coalesce around assigning Lafco because Lafco said they don't want to take the responsibility, then there's
Lafco.
What? Then no, yeah, Lafco. Then there's nothing for us to do. I don't think we forced Lafco to be named, and that's where the third option comes from. But if we go back, that was the original option before it was suggested last time. So my only point is, how do we force someone to take over that responsibility?
Good point. So good questions. I think I'm going to open it up to the public now to see if there is anything that the assembled multitude would like to say. But before I do that, I see that Director O'Connell has, well, let me go to the public and then I'll bring it back to the board. Okay, I see Wendy Strimling has her hand up, so go ahead, and then I see Kate McKenna.
Maybe you want to take Kate first, or well, I can go first.
Your hand was up first. Go ahead.
Okay.
Live it up.
All right. A number of thoughts. One of them is, in really pondering this over the last couple weeks, it does seem like, in a way, this is what courts are for. That if the FORA transition plan does assign the obligations and responsibilities, in the sense that it acknowledges that over the last year, various agreements have been entered that do assign the various responsibilities, such as the property transfer, ESCA, winding up the affairs of FORA, what to do with the CFD funds. Like, those are clearly were assets and obligations, and they have been assigned by binding agreements. But now we're sort of in this realm of the unknown, things we don't know about, but that could come out of the woodwork. I think there's a real danger in the language that says it's going to be all of the member jurisdictions' joint and several liability. That just invites litigation against all of us as member jurisdictions. So on behalf of the county, I would recommend against that language in particular. That is both in 1.5 and in 3.1. I understand Lafco's concern that why should they be held liable, and it just invites litigation against Lafco. So having said that, I want to speak specifically to 1.5, 2.2.8, and 3.1. And so with 1.5, I would recommend language that says something like, following FORA's dissolution, it is the intent of FORA that no member jurisdiction shall be held responsible for FORA's actions or inactions in any litigation challenging FORA's compliance or alleged lack of compliance with applicable law relating to FORA's records. I can screen share this, possibly that might help. Well, I don't need to, I can just read it out loud. But the idea there being that really, why, if it's going to be the county, we don't know what FORA decisions FORA made, so why would we be held liable? Why would the city of Seaside be liable? Why would the city of Marina be held liable? It just seems like FORA did what it did with regard to its public records. And then if some plaintiff wants to raise an issue, we will, and they name everybody as a defendant, we'll go to court, and that's what courts are for. I mean, they'll have to resolve this sticky wicket, to which there's not really a resolution. And I think that's why the board here, FORA board, is struggling. While we're on 1.5, I just want to correct one point about the attorney-client privilege records. What the county said was, what do you want to do about it? Because as those of you who are attorneys know, it is only the client is the holder of the privilege. So if you were to transfer those records to the county, we couldn't access them unless the FORA board waives the privilege as to all of those records. So that's really the question. If you want the county to be the repository of all the attorney, or Lafco or some other entity to be, or RGS, Joint Powers Authority, to be the repository of these records, you have to waive the privilege and let us have them. And then we would be going through, and it might be actually quite hard for us to evaluate on those that are close calls. What obviously your closed session memos are privileged, but other things, we would. So in a way, I think the logic, and I'm not a private, I don't, I think as I understand it, like in trusts and estates, and there's other areas of law where attorneys do step in on behalf of the client. They have sort of a fiduciary role. And I'm assuming that's why Kennedy Archer suggested that they would be the ones. I don't think they're going to make money off of this. In fact, they'll probably lose money off of it because I don't think they're going to be paid to go through the records. But you know, I think the issue is that I don't know who it's like a fiduciary responsibility. So unless you want to waive the privilege and give that another public entity the right to be basically step in the shoes of the client, there's a real problem there. I mean, I think it might be a violation of the evidence code to give the county those records. So
thank you.
That's
Thank you,
that
Ms.
issue.
Thank you, Ms. Brimling. Your time is up, so I'm gonna.
All right. But I have
thank
a suggestion for 3.1 as well. So
Okay.
I just wanted to say, can I come back to me for 3.1 when we get there?
You maybe, or can you email your suggestions to Mr. Willoughby so he can see them, and maybe
Okay.
to Harry or someone at FORA so that it can be screen shared from there?
If that's acceptable to the board, I'll do that.
Yeah, I don't know if that's okay or not. It's probably a legal question. I'm just trying to find solutions on the fly here.
Well, if it's going to be screen shared, please CC Harry, because I don't have the ability to do that.
Well, I'll send it to you all and then you can decide what you want to do.
Great, thank you. Let's see, Ms. McKenna is next, and then Sherry Damon. Thank you.
All right, thank you, Chair, and good afternoon, everyone. I'd like to request your attention, please, to a letter that Lafco sent out by Harry and Josh a couple of days ago pertaining to these latest updates. In that letter, we let you know, first of all, that the Local Agency Formation Commission did open a hearing on the dissolution matter this past Monday and continued that hearing until August. And the primary reason it was continued is because of Lafco's concerns about the fairly last minute updates that were being proposed that adversely impacted Lafco, pertaining to sections 1.5, 3.1, and 2.28 of the transition plan. Essentially, Lafco objects to the unilateral or the attempt to unilaterally shift FORA's successor responsibilities onto Lafco, or for that matter, onto any unwilling local agency here in Monterey County. We do accept, I'm encouraged by some of the discussion this afternoon, that perhaps it's okay to have some uncertainty as we all move forward, and that it's okay to have a few gaps in this transition plan. For instance, our understanding of the FORA Act is that it does not speak to unknown liabilities. Therefore, I think there is some room here for FORA to take an action that would be beneficial both to Lafco, which all of our land use jurisdictions are part of, and to your individual FORA board members. We also object to the attempt to unilaterally expand the use of the $500,000 litigation defense fund that Lafco has. Those funds were intended for Lafco's legal defense if we are caught up in a FORA matter, and that any attempt to unilaterally change the terms for use of those funds would be contrary to the language in the signed indemnification agreement between FORA and Lafco. And therefore, what I'm requesting at this time on behalf of my commission is that you, with respect to sections 1.5 and section 3.1, that you eliminate all references to Lafco. With respect to section 2.2.8, we are also requesting that you would eliminate the references to Lafco. And I appreciate again, the consideration being expressed today to also only make those assignments, those catch-all assignments to the member jurisdictions of FORA if they are willing. And what I'm hearing today is they are not. And just as Lafco would reject any attempt to forcibly be assigned such responsibilities, we would encourage FORA to give the same consideration to your own members. Thank you.
Madam Chair, I think you might have been muted. We didn't hear you.
I pushed the button to mute myself instead of to unmute. Thank you. Let's see. So next is Sherry Damon has her hand up, and then Kelly Donlin.
And Madam Chair, if I can just interrupt, I don't have a hand to wave. Warren Poitras here. I'd like to speak as well whenever it's appropriate.
Thank you. I will put you in the queue. Thank you very much for speaking up.
Yes, thank you, Madam Chair, members of the board, Sherry Damon. I guess I would concur with the comments of Ms. Stremling that a statement at the beginning of 1.5 about no liability to any member jurisdictions for FORA's prior acts would be a wise idea. Also concur with some of the statements of Ms. McKenna with respect to the Authority Act and the dissolution provision, both for Lafco and the transition plan. Transition plan is not required to assign unknown liabilities out there. And so I guess my suggestion would be that we delete in total 2.2.8. All of those are unknown liability provisions. And I would also concur that the blanket assignment provisions in this plan, the catch-all provisions, be eliminated. So that would be in 3.1, 2.2.8, and I think Ms. Stremling brought up 1.5. And that, I think, my other comments have already been captured in this draft document. Thank you.
Thank you. Ms. Donlin, you're next, and then Mr. Poitras.
Thank you, Chair Parker, and good afternoon, board. I am Kelly Donlin, General Counsel for Lafco, and Ms. McKenna summed up very well what our position is. One item I did want to add is the number 4, which is at the bottom of the transition plan on number 71. We would ask that Lafco being mentioned in that section remain, regardless of the changes that are made above, because it's just extra protection against any claim against Lafco's general funds not associated with this matter at all. So I would add that to Ms. McKenna's comments. Thank you.
Thank you. Mr. Poitras, your turn.
All right, good afternoon. Warren Poitras here. I'm a Lafco commissioner. I represent Monterey County Regional Fire District. As a Chicago journalist, Peter Dunn quipped way back in 1985, quote, "Politics ain't beadbag," close quote. This oft-quoted aphorism applies today, watching the machinations of the FORA board, as the dissolution clock winds down to zero. It's long been obvious that FORA has no intention of increasing the amount of money allocated to the defense fund of Lafco, and it's now clear that FORA has been doing everything it can to leave the Lafco commission holding the bag just 5 days from now. The FORA board seems to be doing its level best to ensure that Lafco is forced to shoulder FORA's responsibilities and liabilities once this body ceases to exist. This is neither fair nor reasonable. Lafco rejects these successor responsibilities. We have no intention of using 1 penny of our defense fund to even partially pay any obligation, claim against, or liability of FORA. This money will be set aside by FORA to help Lafco mitigate the litigation costs we will surely incur once FORA is no more. It is in this highly litigious environment, $500,000 will not cover the costs Lafco will face from even a single lawsuit, let alone the high volume that can be anticipated. Under such circumstances, this money we simply cannot spare. Several board members also serve as Lafco commissioners. No matter how much some of you might want to rid yourselves of all this controversy, these issues will still be there waiting for you when you wake up next Wednesday morning. As you know, I represent the interest of special districts on the Lafco Commission. There are 42 special districts in Monterey County, none of which have any direct interest in or stand to benefit from the outcome of all this litigation. But once the $500,000 defense fund has been expended, Lafco will have no choice but to use its own resources to defend itself from manifold FORA-related lawsuits. Thus, Lafco will have to look to its member agencies and by extension their taxpayers for additional defense funding. So please, ladies and gentlemen, consider seriously the consequences of the decisions you are about to make today. The taxpayers of Monterey County expect and deserve a fair shake. From what I've heard during the discussion, I'm given hope that there may be some light at the end of the tunnel, and I hope you will see your way clear to do as some have suggested and stop aiming at Lafco to shoulder these responsibilities and litigation down the road. Thank you.
Thank you, Mr. Poitras. Any other member of the public wishing to make a comment on this item? Okay, I'm not seeing any blue hands. Are there any human hands in the screens? I can't see them because I don't see very many pictures, many screens. So I'll bring it back. I'll close public comment then and bring it back to this board. You can see that the language that was being discussed by Ms. Strimling is on the screen now for us all to see and not have to retain in our heads. And I have several board members' hands that are up, Director O'Connell and then Director Phillips. Frank O'Connell, are you there? Did you want to speak?
I am. I apologize. Yes. I don't have any problem with 1.5 changes that Wendy's proposing or 3.1. My question I do have is, as to a change that exists either by deleting the last sentence of 1.5 or taking Wendy's suggestion, are there any other sections other than 3.1 that would have to be modified, David?
Thank you. I think those are the main ones that I've heard referenced, but I can, as it relates, Frank, as it relates to this issue of assigning unknown responsibilities to entities?
Yes.
Yeah, I think these are the two, but
I
I'll
believe
ask.
2.8 is also for consideration.
I'm sorry?
2.2.8?
Mm-hmm. I'll pull it up, Madam Chair.
Okay, thank you.
I'm trying to avoid Monday.
What? You have other plans? You don't want to spend your time with this delightful group of people?
No, I didn't say that.
I see.
But you can assume that.
Apologize, I've got so many versions open and it's just taking me just a moment.
Director Amers, I do see your hand. So we have Director Phillips, then Hoffa, then you. We'll get the question answered as we go.
Okay. I think this is the section that I was referring to, Madam Chairman. It's 2.2.8, and there's a section in here that relates to undiscovered items.
If I might offer, section 2.2.8 deals more with the priority of funds for the payment of these obligations than it does about the assignment of successor responsibility, although it is clearly a change that Lafco would like to see made.
David, if I may, wasn't there a discussion with Paul or maybe counsel for the city of Marina this morning relating to changing the wording of this to protect the bonds, the revenue?
There was indeed, and before we got into the discussion of comparing attachment A to attachment B, we had up on screen language that I drafted based on that input from Paul, and I received his blessing on the language. Perhaps in Kendall's many screens, she can.
I'm looking for it.
Yeah. My recommendation is that language that does protect the bonds be included in whichever iteration of the transition plan the board wants to move forward with. So it has
this is the section.
Yeah, that's it. And the language in red is or was prepared in response to the comments that Karen Tiedemann shared with the group, and with some additional input from Paul Timig. And I did not hear specifically back from Karen regarding this, but Paul did say that he's satisfied with the language that's on the screen right now.
So I just want to reiterate, so I've got my notes straight. The three sections we're talking about, again, the two changes that are proposed from the county from Wendy Strimling, and then this, which has already been vetted by Paul. Those are the three adjustments, if you will, that would be made in a final, say, third version of the transition. Is that accurately counted?
Along with unpledged.
Yes.
And then I just have, at this point, it might be helpful to go to that option C that we prepared just in case. And I would not put up the clean version. I think there's a redlined version that compares to the resolution that was under consideration at the last meeting compared to this option C, which would be no specific assignment of catch-all responsibility to anybody.
You're killing me, Smalls.
Yeah, you know, life was so much easier before we had this virus thing, and I could be at work, multiple screens, and do things simultaneously. But at home, the technology only lets me do one thing at a time.
Okay, now give me just a second. I'm just pulling that back up again. It'll just be a second here.
While Kendall's looking for that, I might also offer an additional comment on the suggestions that I believe Wendy Strimling put together regarding language saying it's the intent that nobody hold responsibility for anything after FORA's dissolution. My interpretation of the FORA Act and its dissolution provisions are that FORA is supposed to come up with a transition plan that assigns liabilities and designates successors, and Lafco is supposed to implement that so that FORA's obligations are honored. If I were to read the legislative intent behind that, it would be that no third party is left with an unsatisfied claim just because FORA's existence has ceased. So I think what the legislature did by saying, FORA, you put together a plan, and Lafco, you go help implement it, was the opposite of saying nobody's responsible after FORA goes away. But I acknowledge that there is room for different interpretations of this issue.
Okay, I've got C on the screen right now, pulled up to 1.5.
David, you're muted. Mr. Willoughby, unmute.
Kendall, is this attachment C to the board report, or is this the third option that I sent you this morning? Because it's not looking like what I'm expecting to see.
This is C. Do you want me to open something else?
Yes, C is what we were looking at earlier from the board report. The option that would not assign catch-all responsibility to anyone after FORA's dissolution was a standalone or a separate document that I sent you this morning.
Okay.
And if you don't mind my hopping off the screen, I'll try and find the transmittal time.
Is it all right if we go ahead with other board comments while the hunt proceeds?
Certainly.
Okay, thank you. Director Phillips and then Director Hoffa.
Yeah, I don't know whether I totally agree with council's reading of it. You know, I'm not sure there's anything in there that says that we have to anticipate litigation we know nothing about and then assign that. If we sat here now and we knew what litigation was coming, it would be pretty easy to say, well, that should be assigned to this jurisdiction or that jurisdiction. But trying to assign the unknown is speculative. I like Wendy Strimlin's modifications to 1.5 and 3.1. I support those. And as it gets to Lafco, I can see why Lafco objects to the language, and that's why I support taking it out. So they're not just set up for litigation and they're the straw man. But you know, I do take a little objection when we gave them $100,000 now for administration, and we've given them $500,000 for litigation defense costs. That's what they say, that's not going to be near enough. We don't know. They could end up with no litigation costs. And so I think, I mean, we've given them some money to deal with anything that comes up that we anticipate. I think that's been pretty fair about it. But I support the language so that we're not setting them up strictly for litigation. Thank you, Madam Chair.
Thank you, Director Phillips. Okay, so now on the screen we have the version of 1.5 that just stops before the assignment of unknown liabilities. Is that?
Yes, this is the option he had this morning. It's not the exact language that Ms. Strimling submitted during the meeting, but this was a version that David worked on previously today.
And this is the clean version of the document. If you pulled up the red line comparison, you would see where that language we were talking about was dropped out. But
okay,
we can work from whichever the board's most comfortable.
So what I'm trying to figure out is the language then that we're discussing that nobody really likes. So is that just gone from this version? You haven't rejiggered language, you've just eliminated that sentence or those sentences?
In this third option, I have taken out the provisions that Lafco objected to. I have not added in the provisions that we believe Lafco wanted inserted, referring to assumption of responsibilities by successor members. And the result is this third option just doesn't assign liabilities or designate successors with regard to things in the catch-all category. The things that we don't know about but think might come along, they're just not addressed.
Great, thank you. We'll continue with board member comments. Director Hoffa, then Director Ramers.
Thank you, Madam Chair. I've got a couple kind of, I think, big picture comments before I get to sort of my specific feelings about the transition document and the options. One thing I would note is I hope directors think very carefully before we make motions and substitute motions, because we don't want to box ourselves into a position where somebody makes a motion, somebody makes a substitute motion, and then effectively we either are going to be approving that substitute motion, or I fear we may end up in a position where we don't approve a transition plan at all. So please let that sink in, that we need to be, We need to, I think, have a thorough discussion and hear everybody's thoughts before we get to the motion making. I know there's a tendency here to want to jump in, and I want to finish this as soon as possible. Quite frankly, I was starting to think through my head, what would I like to propose? And then I thought, well, what if we end up here stuck, boxed in? So just think about that. Number two big picture thing is I just want to share, I appreciate everyone's interest in trying to make this the best transition document possible. But I'm a little bit uncomfortable about a couple of things with our process. We've got a very good attorney who has been working on this for a long time, who's given us a number of options. But now I feel like we're at the table, in essence, trying to rewrite these options even, and we don't even have all of the documents in front of us. And it's even, our staff is struggling to keep up with all of the various versions. And I just want to caution us not to be trying to make the perfect transition document here at the last minute, and to realize there's one attorney and one consultant who work for all of us, and I think we need to listen to them very carefully. Even though other attorneys from agencies and other public agencies have important comments we need to consider, just remember Mr. Willoughby and Kendall are working for all of us and have been working on this. So those are my big picture things. Now, to get to some of the brass tacks, as they say, what I would prefer, what I think is the safest move would be option A. I believe that option A is the safest direction because I think, option B would leave us definitely, leave all of the land use jurisdictions at risk. I hope that we all agree option B should be off the table. So that leaves option A or option C. Option C concerns me because I think it could actually leave Lafco and the jurisdictions potentially at risk. And so then who should actually bear the responsibility? Well, there's one entity that actually has a legal defense fund post-FORA, and that's Lafco. We've also done, I think, a really good job of trying to tie up all of the legal loose ends. I agree with Director Phillips. I don't think that we anticipate there's a likelihood that there's going to necessarily be anything post-FORA. I think we've done a good job. I think we've given them money, and I think that they are the logical entity. They're the local area formation committee. Like, this is their, if it's not their responsibility, whose responsibility is it? So I'm in favor of option A with the changes that Mr. Willoughby proposed just now for option 1 or for item 1.5, sort of the Willoughby amendment. As much as I respect Wendy Strimling, I didn't get to see her document. I didn't get to read it. She's not my attorney. And I think Mr. Willoughby's was trying to address her concerns. So I'm leaning towards option A with Willoughby's amendment to 1.5. And then the last thing with respect to the Public Records Acts, I think in the end, it makes sense that the firm would sort of be the trustee for those. And I think we heard that from Wendy. I think we heard it from Mr. Willoughby, kind of why we are there. So those, I think, cover all my thoughts, and I look forward to hearing what other people have to say.
Thank you. Thank you, Director Hoffa. We'll move now to Director Ramers and then Mr. O'Connell.
Thank you. I appreciate what Mr. Hoffa said, and I agree with what he said. One of the comments that I did listen to was that there, without a designated group going forward like Lafco, such as Lafco, what I believe I heard was that all of the current members of FORA board could become liable to any action taken going forward. And that I did perk up my ears on that, because that would mean that we in Carmel by the Sea would be party to it. And what we have been discussing are the going forward with the jurisdictions that actually have property and are going to be in charge. And that's what I certainly expect and support. So I would be very concerned if by not having a designated group going forward, that we then Carmel, Pacific Grove, and Sand City would also become liable. And that's a very worrisome place. Plus the fact that we have given $500,000 designated for support for going forward. Thank you.
Thank you. Director O'Connell.
Thank you, Chair. On the screen, I see 1.5 with the red line version. I assume that's the red line version based on what was sent to Kendall this morning. Could you go down to 2.28, please? Now, is this the final version that makes reference to the protection of the bonds? Or is there wording that is to be added to this? Or do we have a final version that we could call Exhibit D instead of C or E or F, whatever?
This is what we've been calling the third option, or alternative C. It was actually prepared last night before comments from Marina regarding section 2.2.8 were received. Earlier in the discussion today, I recommended that we use the changes to 2.2.8 that came in this morning, irrespective of which direction the board goes with regard to the question of, should catch-all assignment be made to Lafco? Should it be made to member jurisdictions? Or should it not specifically be made to anybody at all? Under any of those variations, I still recommend that you use the 2.2.8 version that was developed this morning and that we looked at a few minutes ago.
And then as to 3.1, the wording that Wendy proposed, or is there wording that needs to be changed if we were to accept the morning version? I'll call it the morning version.
Maybe Kendall can get it back up on screen, but in 3.1, the third option, the let's not assign it specifically to anybody version, would delete from section 3.1 the parts that Lafco objected to, and it would not include anything designating the members as successor responsible.
And, okay, for purposes of being somewhat brief, how would we reference this as to what exhibit we would be making a motion on? So for example, we did not want to go with A or B. What would we call this? Exhibit D?
Well, my suggestion would be that if you were inclined to make a motion, you would say that that the board intends to approve the third version, the one that does not make specific catch-all assignments of responsibility to anybody, with the following modifications. That section 2.2.8 as developed this morning and shown on that standalone slide be used in lieu of the section 2.2.8 that is in the document that's on the screen right now. And that also the
unpledged.
Yeah, the unpledged language in the three sections that were suggested by Seaside be plugged in where appropriate. So it would be essentially this version that's on the screen, incorporating the changes in the standalone slide we had on 2.2.8, as well as the changes on the other standalone slide that dealt with unpledged future property tax increment.
Thank you. Thank you, Chair. David, thank you very much.
Thank you. Question for council, whichever one. With the Kennedy Archer Giffen law firm being the repository of the legal documents from FORA, would that law firm be required to respond to the Public Records Act? Should there be requests for documents?
John, do you want to take that one, or do you want me to address it?
Don't all speak at once. Is he on mute? Where is he here?
I was on mute. I'm sorry. David, if you want to take that, go ahead.
Preliminarily, our firm really doesn't want to take these records. We just don't know of any other willing recipient. Wendy Strimling has expressed the difficulties that would be presented by the county or frankly any other member jurisdiction in trying to take that on. I haven't specifically heard from Lafco, and in fairness, we haven't made a proposal before this meeting that would even consider Lafco taking on that job. But if there's a willing recipient out there, please put up your hand, and we'd be happy to not take these records on. If no one else is willing to take it, and consistent with Lafco's interpretation that we can't force them upon anybody who's unwilling to take them, by default, I guess we would have to deal with the Public Records Act requests. And, that's not only difficult in terms of devoting time and attention to that, but with FORA no longer in existence, the dilemma of how to pay for the time involved in analyzing and responding to these things crops up. And it's a can of worms that we'd rather not have, but there is no apparent easy solution that we've found to this dilemma.
Thank you. Okay, so we've had a good discussion. It looks like some options are emerging, and an option that may be agreeable. Director Adams, I see your hands up.
Yes, thank you. So I'm just trying to figure out the disposition of the records and what is the point of them. Is it to have a place where people who want to make Public Records Request Act will be able to get to them? I ask because I'm thinking it seems like either CSUMB or the Monterey College of Law would be a logical recipient of holding these. They have absolutely nothing to do, well, CSUMB of course has to do with FORA, but who and what is the actual nature and the responsibility of the person who is going to be taking on the records? Is it space? You know, I'm a little bit unclear about this. So I'm unclear about it, why you guys are getting, you know, why you are taking it on instead of somebody else, quite frankly.
Well, among the components of the cost would be, as you identified, space. Probably the biggest component would be staff time to go look through all those records and decide what is responsive to the public records request. Screening the documents to see whether there are any remaining privileges in effect that would call for those not to be disclosed. And then things like copying costs and mailing expenses. This is an obligation that could go on in perpetuity. And then finally, there's the issue of supplying these materials to any third party. The problem is, are you going to waive privilege for all these things? If you waive them for one third party, I believe it's going to be very difficult for you to assert them against a different third party. So if they go to somebody like a library, I'm concerned that the mere transmittal of them to that entity would, in effect, waive all privileges.
Thank you for that.
And it looks like Kendall Flint has something to contribute.
I'll make it brief, Madam Chairman. A couple things, just so that everyone's reminded. There's already an agreement with the county and FORA for the storage of personnel records, EIR, all that kind of stuff. That's going over there, right? And so with the limited time, I think we just need to be realistic. We literally have 2 days. And so we have discussed this with council, and with all love to CAGLA, I think this is one of those things that basically has already sort of been determined and been discussed for quite some time. It's reflected in the county's documents. We don't have any other agreements in place with any other third party to take it. And I'm not trying to, stop the discussion, but rather I think we're at a point where that ship has sailed.
Got it. Okay. Thank you.
Thank you. I see that Director Berkeley has her hand up, and then Director Hoffa.
I'm actually changing the subject a little bit, or the number I'm looking at is 2.1.3 about the litigation reserve fund. Can you pull that up on the screen? Because I've got a couple of questions on that. I want to be sure that before I make a comment, I'm drawing from the latest version of the document. Okay, great. Thank you. So my understanding is that this is basically the template for the assignment of projects. And so perhaps I should be saying, simply stated, like, FORA contracted with Marina, FORA contracted with Seaside, et cetera, and name each of the land jurisdictions instead of that paragraph. And then, actually, if you can go on to Director Hoffa, that would be great. I just need to check one other area in our document.
I need to ask one question. Is it 2.1.3?
The litigation reserve funds, is that correct?
Yeah, so that paragraph is very specific to an agreement already in place with Lafco, by which they received $500,000 for litigation.
Oh, okay.
So that agreement was signed in December of 2019.
Okay, thank you for the clarification. Okay, and then if you can go ahead to Director Hoffa, and if I've got something else, I'll come back then. Thank you.
Okay, great. Thank you. Director Hoffa?
Yeah, so I appreciated hearing from a couple of our directors on kind of how they're leaning, but I think it would really be helpful if every director could speak to, we could go around, where are you on the substantive decision points? And maybe Kendall can kind of help clarify them. As I see it, there's who do we want to assign the sort of undesignated responsibilities? Do we want to assign that to Lafco? Do we want to assign it to the land use jurisdictions? Or do we want to leave it ambiguous and let the courts decide? That's sort of decision point number one. Decision point number two has to do with the undesignated or the unpledged funds. Do we want to include that updated language or not? And I think decision point three has to do with the public records. Do we want to go with the current recommendation to assign it to the law firm, or does somebody want to step up and say, no, I'd like it for my jurisdiction? And then I'm not sure what other sort of specific decision points, but I think it would really help us craft a proposal and maybe a substitute proposal if we could kind of get some sense of the consensus of where people are on the key decision points.
And I like your list, Director Hoffa, although I think well, okay. The only other one that I've heard articulated is the language protective of the bond that would be in 2.2.8. That seems like it's helpful. I mean, it's being recommended to us. Okay, Director Oglesby has his hand up, and then Director Gagliotti.
Thank you, Chair. I'll take the easy one first. I think we already spoke about the public records. unless someone is going to volunteer, and I don't think they're going to volunteer today on Friday. So it's unfortunate. But again, you know, as the FORA board, you know, we can go around and around and try to figure out how to settle each issue, but it's not like we haven't talked about it before. So it's a reason why it's not been settled. And it's a reason why we are, by not volunteering ourselves, we're requiring our outgoing legal firm to take it over. And that's unfortunate, but we're adults. We see that's what we're doing. I'll go back to the successor to FORA. The FORA board, and maybe I'll just speak for Seaside, there's no successor agency to the FORA board. It goes away. And so when you're talking about what's left to sue over, or what's left to sue because FORA did not complete it, we have a list of things that we completed. We have agreements with certain agencies, the city of Seaside, what is it, ESCR and the LRA, and then Delray Oaks, and the county is doing their part. I think as the board, we need to have a closeout document saying we have completed our mission of assigning our obligations and there's no more obligations. And we shouldn't act as though, well, we assume someone is going to sue us because they say they're going to sue. Well, that's their right. But as a board, we should say we completed our business, and that's it. I understand Mr. Willoughby by saying it's in our legislation that it be clear if we designated Lafco, but Lafco clearly says they don't want to be designated, and then there's not enough votes to make it not mandatory, but just put them in the document. We know that. And so we should just affirm that we have closed out our business and it is what it is. And we should be proud of that. Just because someone is saying that they're going to sue, we should not be turning over the document 3 or 4 different ways. And all we come down with is either we're going to put Lafco in or we're going to put the land use jurisdictions in. As far as Seaside is concerned, we have accomplished our mission. There's nothing else for FORA to do but close out. And there's nothing else to designate because you don't have the votes to designate it. So we might as well just agree that we've done all we can and not let someone tell us that they should have designated everything else out. So I appreciate what everybody's doing. I appreciate what Director Hoffman just said. He makes good points. But I think as we close this thing out Friday or we had Monday, we should be clear about we have done our duties and we have designated everything that's been required to designate. I don't think we have to designate someone just in case there's an issue in the courts and someone needs to be sued. So we designate someone to pick up that lawsuit. So thank you.
Thank you. Director Gagliotti. One more unmute. There you go.
So crazy. Thank you. All right, so I really appreciate Director Hoffa's kind of process because it'd be really easy to just continue to keep spinning our wheels on this. So I want to go ahead and participate on this and see if we can get it to work. So with regard to the records, I think Kennedy and Archer is definitely the kind of the best holder of those records for the quandary that Wendy Stribling raised of the record holder. I think that it makes complete sense that they would hold it. On the 2.2.8, as best I can understand it, I just think the option A or the attachment A describes kind of how to manage or how to handle both 2.2.8 and 3.1 as well as 1.5. Really kind of going along with what Alan said, if I had to choose between, definitely B, attachment B would be off the table for me. It would either be Lafco is the successor agency, or at least the responsible agency to take over these responsibilities that the transition plan is putting forth, and they manage it, or nobody does. And so my preference is attachment A, but if we need to get to yes, I could be convinced to go to option C, but I don't want to do to option B.
Thank you. Anyone else wanting to weigh in? Director Phillips, I see you're unmuted.
Yeah.
You have something to add?
Yeah, I agree with Mayor Oglesby. Frankly, I concur with his line of thought. So.
Okay, so let's see. So I think we're, if other board members don't want to, oh, I see Cynthia Garfield raising her hand. Thank you.
Thank you. I'm going to ask somebody to spell this out to me in very small words. Just so I know, and we've gotten in trouble before where we were tossing a lot of ideas out, and I want to follow up on Director Hoffa's point, is that it's real easy to get off track, not know what we're voting for, get a little confused. So if I may be the one who asks the question, could somebody please explain very clearly? It seems to me that the clarification that tax receipts that are pledged should be the ones that are not already pledged. That's the useful clarification, so no one confuses what we've already allocated tax funds for to do that. So that one I've got. Public records, I've got that one where nobody's stepping up to take this, and the only entity that seems to understand what might be privileged or not, should there be a request, is the law firm. So by default, since everybody else stepped back, they look like they're stepping up. So I get that, but I need somebody to explain to me the other pieces, please. And then also answer the question of, if we're going to remove Lafco from having any accountabilities for litigation, what is the $500,000 for? Anybody?
David, do you want to take a swing or you want me to take a shot?
I was momentarily distracted. What's the question again?
Let me take a shot and then you can correct me. So what I'm hearing from everybody overall, I want to separate out these things. 2.2.8 is that updated language that really protects the bond proceeds. And what I'm kind of seeing around the room is everybody's okay with that. What we're really coming down to in terms of discussion is whether or not we name Lafco as not a successor, but as it say a potential litigant in FORA's stead, or not, because none of the jurisdictions want this falling onto the local agencies. I think the things that relate to the unpledged funds are also universally supported. I don't see anybody worrying about that. So the fundamental thing here is, do we include Lafco or not? And I think what that really comes down to, I think what Alan was getting at is if we can look around the room at the board, and if there's not support for keeping Lafco in, then I think you're looking at option C, updating that language at 2.2.8, updating the language to include unpledged, and just removing all those references to a future assignee. And to me, it's that clear. Did that make sense, Cynthia?
It does, and I appreciate the clarity of that. The last little question is, what's the $500 for if Lafco has no accountabilities?
So the good news on that is Lafco's litigation fund. I think we all know, if you spent any time in the lovely Monterey Peninsula, getting sued, not getting sued, nobody knows. Anybody can sue anybody. And so even by removing Lafco, it's absolutely possible that someone could go and sue them. However, the agreement that Lafco has with FORA is that if they are not sued, that $500,000 comes back to all of you. They're not keeping it as like their funding. It is specifically for litigation. So if they're not sued, then that money flows back, and that's part of the agreement that was signed in December. So that there's really no loss on that should something else happen.
Thank you. I appreciate that.
If I might piggyback on that, at least in Lafco's view, the $500,000 is intended as a fund for them to cover the costs of defending the litigation that might come along. And if litigation never comes along, then the unexpended portion of that would be returned to the member agencies. But in their view, that $500,000 is to cover their own costs. It is not to pay judgments or settlements on the underlying actions.
And I think too that Lafco would say that their charge to use that their charge is in making sure that it's a smooth transition. That you know, so their actual responsibility is fairly narrow, and the agreement that FORA and Lafco have spell that out. And unless we want to change the agreement, that you know, they've got their marching orders. We have put some money on the table in case they need it, and otherwise, you know, they're, you know, that's sort of a closed conversation. So
Thank you.
Madam Chair, John Giffen here. I'd just like to piggyback that and say, you know, the law firm Kennedy Archer and Giffen is going to take responsibility for these records, and I think it's appropriate to at least ask the board if they would help support those efforts. This is going to be an obligation in perpetuity, and I would request some kind of funding to carry out the client. We would be carrying out the client's interests in responding to the Public Records Act, and the county has money for their administrative and record keeping obligations. Lafco has $500,000 for just defending themselves in litigation going forward, and I just would make that request that the board consider an amount of at least $100,000 for us to go forward and respond to these requests without getting. It would just make the whole situation a lot more equitable.
Tolerable. Yeah. Thank you. It wouldn't be FORA if we didn't have a, you know, a request popping up that we hadn't planned for. So, but that it makes sense. So I see that Director Ramers has her hand up.
I just have a question for clarification. I did hear, I believe, that if there was no potential, if Lafco was not named or any jurisdiction named for going forward to take care of the potential litigation, that all members of the Fort Ord Reuse Authority during these last 26 years would be liable for any litigation or any action. And I am concerned about that and would like clarification. And if the language is strong enough to protect us as well as the other jurisdictions, I would like clarification. You can, please.
If I understand the question, I think it's going to, each case is going to be a case-by-case basis. So it's difficult to assess what a court is going to decide down the road as to individual liabilities for jurisdictions. So I just think that's a tough question just in the abstract.
Well, may I just add to it that it came up, I believe, when we were deciding and thinking of possibly not going forward with naming Lafco. So my concern is if we don't name Lafco going forward, that we open up all the jurisdictions more, are opened up more to the litigation going forward. And that would include all of the members of the FORA board who now sit on the FORA board, rather than simply the jurisdictions going forward. We've made it clear, I understand, to protect the jurisdictions going forward, and I support that. I am concerned, however, if we do nothing more than that, that we're opening up all of us to further challenges, future challenges. And that is a concern. I think it should be a concern to all of us if I'm understanding that potential liability.
Mr. Willoughby, did you want to unmute yourself and make a comment on that, or?
Certainly. The theory on which a future potential plaintiff might pursue Lafco or the former member jurisdictions of FORA, or a combination of the both, would be, or could be, that the transition plan failed to make designations that it was supposed to make. So if a plaintiff came up with that idea and was able to successfully pursue it, theoretically, Lafco and or the member jurisdictions could be on the hook for an unanticipated liability. If, on the other hand, a designation of a successor responsibility is made, that argument would not be available to a potential future plaintiff. Against that background, we need to bear in mind, though, that we have problems making assignments of liabilities and responsibilities to entities that are not willing to accept them. We talked a great deal at the last meeting about the kind of seeming requirement of the statute that FORA designate somebody and make an assignment versus the effectiveness of that assignment. If the assignee is not willing to accept responsibility for the liability or take over the management of the future litigation, I expect that the defense will be, hey, we were an unwilling assignee and this assignment or designation is ineffective. It doesn't comply with the state of California law, and although FORA did designate and assign, that designation and assignment is not enforceable against us. So that is the defense tack that I would expect an unwilling assignee of these responsibilities to take. And as I've said before, these are the results of what is some fairly poorly crafted legislation that didn't really provide with great specificity how this dissolution process was going to work.
Thank you. Director Garfield and then Director Hoffa.
Thank you. I asked David Laredo, our city attorney, a question about Pacific Grove's liability in a different context. I was asking him about the pension obligations and whether we were jointly and severally liable, the JPA-ness for those. And his opinion was that in that context, we are not a JPA and therefore we are not joint and severally liable for a debt. We've settled that one. You're giving me something that seems to be somewhat different in that it would be something that the case would be based on the member jurisdictions, me, not passing a robust enough transition plan to cover all eventualities, and therefore it was an action that would make Pacific Grove liable. Is that what I'm hearing you say?
Yes, it would be the failure of the transition plan to make a full, complete, comprehensive set of assignments and designations. And as I have mentioned, there are differences of opinion as to whether the statute really requires that or not. And if FORA did not meet the strict letter of the Dissolution Act or the FORA Act's dissolution provision calling for assignment of liabilities and designation of responsible successor agencies, it's unclear that there would be any remedy against FORA or its members at all. I just mentioned the theoretical possibility that a plaintiff in the future might follow that line of analysis and attack the sufficiency of the transition plan and say that it didn't provide a means for everybody who might have claims against FORA to be compensated rather than just being told that they're too late and there's nothing to give you.
Don't know what to do with that, but thank you.
Yeah, it's as clear as ever. Director Hoffa.
Okay, so I think we're to the point where there's clearly, I think, two options, and so I'm so I'm going to try making a motion. Somebody may make a substitute motion, and then we'll figure out where the majority lie. So I'm going to make a motion that, first of all of the items Kendall talked about that I think there's consensus on, the updated 2.2.8 language, the language about the unpledged, and also regarding the public records, that our law firm would retain possession. And I would like to add that we direct the executive director of FORA to allocate up to 25, I'm going to say 25,000 of any, if it turns out that there are unspent money at the dissolution of FORA, that up to 25,000 of that would be allocated to the law firm to manage public records requests. So I hope that there's agreement on those general things. And then I'm going to also propose that we adopt option A, and it's for all of the reasons that the directors from Carmel and Pacific Grove were just expressing. So if there's I don't know if there's a second, but that's my motion.
I'll second the motion.
We
Carmel.
have a motion and a second.
Director Hoffa, can I just ask for a point of clarification? Was that to manage all Public Records Act requests or just Public Records Act requests concerning privileged documents?
I think I read the lips, privilege, since
Just
those are the ones that you'll be managing.
Yeah, okay, very good. Thank you.
Okay, thank you. We have a motion and a second. I see Director O'Connell's hand.
Yes, I'd like to take a substitute motion, and I'm hoping David will work with me. I believe it's Exhibit C, that I would make a motion as to section 1.5, delete the last sentence of that. As to 2.2.8, add the reference that protects the bonds that was discussed earlier this morning. As to 3.1, the words that were lines that were stricken, as to the copy we saw, include those. Any additional modifications that are necessary resulting from the deletion of the sentence in 1.5 would be also made throughout the document. That's my motion, substitute motion.
Second.
Thank you. So we have the substitute motion. Director O'Connell, is it fair to say that what you're suggesting in sections 1.5 and 3.1 is the deletion of reference to any catch-all responsibility assignment?
Yes, that's it.
Thank you.
Unless David is interpreting it some other way, because I am relying on David as far as what he had stated like 5 minutes ago. Or maybe it was an hour and a half ago.
Just for clarification, do you also want to include those 3 insertions of words that were suggested by beside?
I'm sorry, again?
The 3 I'm sure Chair Parker can remember the specific word.
The word unpledged, I think
unpledged.
It's non-controversial, it's a
And the
clarification.
2.2.8, just the update from this morning. I mean, the real gist of it is basically no Lafco, no assigning.
Okay, and for further clarification, I understand that we're talking about the 3rd variant, the one that was developed last night and discussed among staff this morning, modified as Director O'Connell indicated. Does the proposal include anything with regard to additional language about there being no intent to saddle anybody with responsibilities after FORA goes away, or is that not part of your motion?
I hadn't got it in there, but is it, in your opinion, something that should be put in for purposes of protection of jurisdictions?
It frankly worries me because it seems inconsistent with my interpretation of what the FORA Act is saying. It's kind of the difference between almost turning a blind eye to what could be a requirement to do full and robust assignments versus directly contradicting the provision that says you shall make assignments.
So are you suggesting, again, that that be included?
I'm suggesting that it not be included.
Very good. I go along with you then. I'm relying heavily.
Great. So I think, so we have a motion and a second. I guess I would just ask, Director O'Connell, does your motion include the direction to the executive officer to scrub the books? And if $25,000 can be found to help offset the costs of the Public Records Act request on the privilege documents, that be allocated to the Kennedy, Archer, Giffen law firm?
I will include that as long as it's some type of a condition that if those funds are not applied within a certain, say, a 5-year period, the balance existing be distributed to the appropriate jurisdictions.
Okay, thank you. So I think that's clear. We have a motion and a second. Director Oglesby and then Director Adams.
Thanks, Chair. That was my point. But I do feel that $25,000 is a little low. I don't know if 100,000 was outside the ballpark. We need to make sure that those attorneys are compensated for keeping our record. None of us want to hold those records. So, if you guys think 25 is enough, I just wanted it to be a little bit more. But I think it's a good motion.
Okay, thank you. Director Adams?
Right, I was going where Ian was. I wasn't willing to go quite as high as 100, but I'm sure happy to go to 50.
Okay, we'll see. Is the maker of the motion open to, the maker of the substitute motion open to a friendly amendment to have the amount go up to 50,000, particularly with the proviso that if it's not expended for purposes that within 5 years that it be revert to the entities?
Certainly.
Okay, thank you. We have a motion and a second. Director Garfield has her hand up.
Just to check all the boxes with the maker of the first motion, also be willing to go up to $50,000 so that we're looking at apples and apples.
Yes.
Thank you.
Okay, shall we do it? We have a motion and a second. We've had a good discussion. Seems like we've covered the points. And so, Mr. Tregenza, would you call the roll for a vote on the substitute motion?
Supervisor Jane Parker.
Aye.
Supervisor John Phillips.
Aye.
Supervisor Mary Adams.
Aye.
Councilmember John Gagliotti.
Aye.
Councilmember Frank O'Connell.
Definitely aye.
Councilmember Lisa Berkeley.
Aye.
Councilmember Alan Hoffa.
Aye.
Mayor Ian Oglesby.
Aye.
Councilmember John Wizard.
Aye.
Mayor Marianne Carbone. Councilmember Cynthia Garfield.
Aye.
Councilmember Janet Reimers.
I really want to say no because I don't agree with it, but I won't bring us all back for my one vote. But I really do believe we're making a mistake, a huge mistake. And I hope our city won't end up paying for it. Or maybe abstain. Does that bring us back though if I abstain, Mr. Attorney?
No.
So I
Does not.
can't. I can abstain and it won't change, won't make us come back to another meeting. Is that correct? Okay, I will
Can
abstain.
she abstain and if she does not have a conflict of interest?
Sure, you can abstain anytime.
Yeah, no conflict.
And I won't be bringing people back. I won't be causing that. Okay.
Correct.
Very constructive. Thank you.
Okay, wow, that was very creative. Good work, everyone. Well done. So that means that we better turn the floor over to our executive officer for a swan song here. Take it away, Mr. Metz.
Well, thank you, Chair and members. Robust and fitting conclusion to this experiment, and I won't keep you too long, I promise, but given all the kind words that were shared about the team's work and my involvement with that, please allow me to offer just a few here that I have, and they are summarized in the report. You know, this is a 26-year effort that has now come to conclusion. It has transformed the former Fort Ord military base, 45 square mile area set between the beautiful Salinas Valley and the Monterey Peninsula, from a Army installation into a thriving set of new communities centered around educational centers, CSU Monterey Bay chief among them, but also including Monterey Peninsula College, Monterey College of Law, and UC Santa Cruz, among others. The future really is, I think, bright for the area. There's housing, tremendous amount of housing under construction. In order to enable that construction, there's been a significant amount of work done in environmental remediation, in water remediation, in removing unexploded ordnance and munitions and explosives of concern. There's been close to 4,000 old buildings either reused or removed, and indeed that will continue when you're gone. There have been 18,000 of the 28,000 acres here preserved in some form of conservation, either in the Fort Ord National Monument, the Fort Ord Dunes State Park, the UC Fort Ord Natural Reserve, and other habitat management areas throughout the former base. There's been significant new transportation infrastructure built, 32 miles of roadways paid for in large part with external grant funding and developer fees. There's been major work done on transforming the transmission of stormwater and removing that from a direct outflow into the bay, which is, of course, is a national marine sanctuary and center of the region, and a attractant of tourism, as well as a place of study for science and ongoing research, and it's really a gem of the world. You leave a legacy of still support of the veterans community and the military communities that still exist here, with the establishment of the Central Coast Veterans Cemetery, the Joint Department of Defense Veterans Administration Clinic, which is the first of its kind in the country. It's right here in Marina, brand new building. There have been a significant number of public convenings, including these used to be monthly meetings, but in the last 6 months, it's been at least a couple times a month, if not more. There, from when I got here, there was the 2012, well, prior to my arrival, there was the 2012 Base Reuse Plan Reassessment Project, which was a major community engaged process to revisit the reuse plan. Then in 2013, there was the Fort Ord Colloquium, which brought together many thinkers and leaders at CSUMB to talk about the way forward. We followed that with the Fort Ord Trails Symposium. It was a catalyst of bringing together numerous disparate trail planning efforts, and now has resulted in the actually support and approval and funding of the Fort Ord Rec Trail and Greenway. Kudos go out to all the partners involved in that. That's going to be coming our way, linking the Monterey Bay Scenic Trail with the Fort Ord lands and the communities. There was other stuff that was organized along the way, regional cannabis policy forum. There was the Monterey Bay Sustainable Hospitality Summits, which many of you participated in. Of course, our drone automation and robotics technology symposium, which will continue, and just recently the Monterey Bay Regional Opportunity Zone Investment Forum. This was all products of your direction and leadership, and I think have contributed to a bright future in front of us for the region, along with the support of the Monterey Bay Economic Partnership, the Central Coast Marketing Team, various chambers of commerce, the Startup Monterey Bay Annual Cycle of Innovation, and others. And so those are some of the big picture items. And just because I have the floor, I will take a moment to run through again some of the metrics that this team that could not have accomplished without being the team that we are, and many of you here have just, well, all of you here have just been through with us. It looks like 40 board and administrative meetings over the last 6 months. The transfer of the ESCA LRA designation to the city of Seaside, which we continued for regional benefit. Just today, I've signed the final out deeds for the remaining 8 parcels of Army from the U.S. Army to FORA that are now going to local ownership. So that's a big accomplishment. All of that, you know, there's a huge back history to that and many twists and turns, but that's all done. Along the way, we also undertook this, navigating this rather contentious and somewhat long-burning discussion of habitat conservation, and we found a way forward that provides the funds to your jurisdictions to steward in the ongoing management of the conservation lands here, and with a potential still future of a regional solution there, including the certification of the environmental impact report for the Fort Ord Regional Habitat Conservation Plan that was just accomplished. Yesterday, I think we finalized the transfer of $12 million in capital improvement program funds to the cities, including the assignment of CEQA lead agency status to the cities of Marina, Seaside, and Delray Oaks. We completed the reimbursement of capital improvement program funds to the tune of $2.5 million to the MCWD, the city of Marina, and the county of Monterey. This year distributed close to $500,000 in caretaker reimbursement funds to local jurisdictions. Finalized just today, I signed the final waste management manifest for the 70 World War II era barracks that are now removed from Sea Deck Hill above our office. If you haven't been out this way in a long time, it's a brand new landscape there. They'll be taking the dirt out through the end of next week, and then that should be a done deal and ready to undertake and take on the next set of building removal that will be funded by the successful securement of a $30,700,000 tax revenue bond issue that took, as you all know, over a year and a half to complete, with many, many potential landmines along the way. So that is a huge legacy that you're leaving for the region, and is going to really change the landscape even more. You also completed the certification of the Campus Town Mixed Use Consistency Determination, which paves the way, again, giving further momentum for the city of Seaside to build the amazing new community that will be there for all of us to enjoy. And again, just noting your continued support of the drone automation and robotics technology economic cluster activity with UC Santa Cruz, CSUMB, the Naval Postgraduate School, Joby Aviation, City of Marina, and many others. I think there's a lot of momentum there, and I look forward to continuing to work on that issue with many of you. And of course, all of the numerous administrative and legal complexities, the memoranda of agreements. Big kudos to Mr. Willoughby and the team at CAG Law for all of that work. John Giffen leading the way, and including the negotiation of the joint and drafting of the joint community facilities agreements that are now all signed and fully executed, that provide for the transfer of the funds to support the habitat. Indeed, the negotiation of this 2018 transition plan update, which you all just clocking in a good 3-hour discussion, and the other related items. So in addition to that, you have navigated concluding and resolving many potential litigious matters so that you leave a very small, if any, set of potential litigation matters for the region to wrestle with. And I think while some may think there are many, from where I'm sitting, there are very few, and I think you've done great work in directing all of that. So congratulations for that. And I will just say, because we look out the window or we read the paper and there is this ongoing crazy pandemic happening, just to note that we managed all of that in the face of this burgeoning global pandemic, a resulting economic collapse, and those effects will continue to affect all of us for the months ahead, unfortunately, and years ahead. And then, of course, all of this debate and international unrest on the really critical issues of equality, civil and human rights that are really so important to address. So I think it's just, again, with some professional pride, but also humility and thanks, I would like to offer to you for the chance to have this position and to work with this team and to work with you all these months. And I really do appreciate it. You know, I have been at FORA for almost 7 years, and in that time went through my own transformation. You know, I came in without a child. Now I have a 7-year-old daughter. My dad was still alive. He's no longer with us. And things are a lot brighter for me on my end. So it's much appreciated for all of that opportunity. And I look forward to continuing to work with you in various capacities going forward. I know I could speak for the whole team that it has been a really great experience. So thank you all very much. And with that, it's got to be close to 5 o'clock and some kind of happy hour somewhere. So thank you very much. And that concludes my item.
Thank you, Josh.
Thank you, Josh, so much.
Thank you.
Any board members want to make further comments? I see lots of clapping hands in the screen. Director Hoffa and then Colonel Ford.
Well, Josh did a great job of kind of going over the accomplishments of his team and of the board, past and present. And I think there's a lot to be proud of. This agency's had its critics, and some of it justified, some of it not justified. But on a personal level, we acknowledged Josh earlier. I'd like to acknowledge our chair. I think she's done a great job of guiding us through this difficult period. And I also just wanted to acknowledge all of you, and you know, today in particular, but really the last 2 or 3 months, I think this board has operated at a very high level. We've dealt with extremely difficult issues, and I think we've done the absolute best job that we could. So congratulations to everyone, and it's been an honor and a privilege to work with you all.
Thank you, Alan. Colonel Ford.
Thank you, Chair. So as the federal representative here who's seen how you transformed what was once one of the gems of the United States Army into what is a huge potential in the future, I want to say thank you. Fort Ord was a destination of choice for many of the Army for many years. What has occurred at Fort Ord since 1974 has made our nation stronger. What you have done here positions the peninsula stronger, which makes the nation stronger. CSUMB, the Panetta Institute, all those things that Josh described are all credit to you and your predecessors. And for me as a professional soldier, I'm just glad to see someone take care of our land and convert to something that can be better for the nation. I always wanted to be assigned at Fort Ord. I never had the chance because it bracked before I got commissioned. So it took me 24 years to get here, but I'll tell you that it was worth the wait because I work with people like you. And although I was very quiet and never had a vote, I truly appreciate the civil discourse you had here. I know it was never easy, but you all engaged in conversations and you had a professional manner of doing so, which the rest of the nation can learn from. So I just want to say personally, thank you. As a U.S. Army officer, thank you very much for all you've done for our nation.
Thank you, sir. Appreciate your words. Any other board members with comments at this point. I do want to open it up to the public in case any members of the public want to respond to anything that Mr. Metz has said. And Director Garfield, I see your hand. I'll catch you after the public. I do see Mr. Cheshire. Please go ahead.
This public comment is what you're doing, Chair Parker.
This is public comment on this agenda item. General public comment will be after this.
I'll just wait. I'll wait. Thank you.
Okay, great. Thank you. So seeing no other hands up for public comment, I'll bring it back to the board, and Director Garfield, you had your hand up.
Thank you, Chair. I really missed the opportunity that we might have had under different circumstances to get together. It's been really hard to be physically separated, to be two-dimensional.
Mm-hmm.
And I look forward to an opportunity when we can sit and reminisce three-dimensionally in the future. We will get there, just not for a while. Anyway, it's been a pleasure. Thank you all.
Thank you. Thank you. And I do just want to express my appreciation again to our executive officer and to the comments of Director Hoffa. You know, I don't know if it was the leadership of our executive officer or whether we rose to the occasion of, you know, really needing to do a lot in a short time frame. But whatever the ingredients that propelled us in this direction, I also want to express my admiration and appreciation for the quality of conversation in this last 6-9 months. We've had conversations and discussions at the FORA board where we all went to our corners, and you know, there was no enticing any of us back. You know, so. You know, into solution, into the center. So, but that interest in finding consensus, or finding as close to consensus as we could get, has really characterized the discussions in the last 6 months, and through very, very complex and weighty, I mean, huge consequences to the actions. So I just want to thank this board for really being thorough in the discussions. It's been interesting to watch where we start in one place and through the discussion we end up in a different place, but really thoroughly vetting the issues. And so thank you everyone for being here, meeting after meeting. They go long, they're not easy, and you've been here and you've stuck with it, you know, right here to the not so bitter end. So thank you all very much. And thank you, Josh. Really appreciate you and your facilitation and your insistence that, you know, if we try, we can come up with a solution that promotes the common good. So really appreciate your insistence on that. With that, I'll move us then to general public comment. And I know that Mr. Cheshire has something that he would like to say, so please go ahead.
Thank you, Chair Parker. It's been a long road. FORA's work is done, but the work continues. I think that all of you may come away from this whole process maybe having a little bit more appreciation for development, the process that developers have to go through. After all, you have been developers of this land. There are a couple things that we need to do moving into the future. Number one is we really do need to take care of the issue in regards to the remaining blight. Now you have X amount of dollars to divide amongst yourselves, and we all know that that will not take care of the whole situation. So sometime in the future, if Congressman Panetta is able to identify a source or so within the federal government for funding, we're going to need to come together to take care of that issue. The last thing I want to leave you with is that in order to build communities, within your own jurisdictions. You need to work with the people in your community. I guarantee you, construction has changed a lot. You're no longer committed to basically taking the lowest and largest mistake bids. There are ways to look at construction now in a different light through new legislation that's been passed in the state over the last several years. So remember the people that live within your community, try and uplift them, elevate them, make them good little taxpayers, provide them with work and such. And that's a political decision on your part. So in my remaining time, I look forward to working together with you in your communities. I'm working in regards to training and education, and I hope to uplift many of the citizens within our community. I thank you very much for being able to allowing me to engage in this process. Like I said, it's been a long endeavor, and regardless of what anyone says, you did what you could, you did your best, and I guarantee you, you did what was right because you did what was right by the community. So thank you very much.
Thanks so much, Mr. Cheshire. Appreciate you, appreciate your comments. Any other member of the public wishing to comment on any items not on today's agenda? I see Erin Harwain's hand. Please go right ahead.
Thank you, Chair, and thanks FORA board. I chickened out earlier and I didn't speak up and raise my hand, but I do want to thank all of you. I've worked with you all for so much, so many projects over so long of a time, and I'm a little emotional. That's why I chickened out. I appreciate everyone's hard work on the habitat conservation plan. And sorry, I'm a crier. And I know I'll see all of you again and work with you again. And I just, you guys really kicked butt the last 6 months with the habitat working group and making some really complicated decisions. And I've been on Fort Ord since '95 when CSUMB first opened, and I'm hoping to continue working on projects on Fort Ord. It's a passionate thing for me. So thank you all for working so hard and making tough decisions. And I look forward to seeing you all soon.
Thank you, Erin. We appreciate your work. It's been really great to work with such a professional, and you know, you just keep showing up, responding to the questions, responding to the issues. It's really, really a pleasure working with you. Any other members of the public wishing to comment on anything not on today's agenda? All right, I'm not seeing any hands. So let's see, we have, are there any items from members? Boy, lots of bites at this apple here today. Anything for the good of the order? You can't suggest something for a future agenda, so you know it's kind of limited.
Chair John Giffen here. I'm not
yes,
a member.
Yes, Mr. Giffen, please.
I did want to say, I reported out from closed session that we had that the board had authorized a settlement, but I anticipated that we would have another meeting, but just to make sure that I've covered my responsibility as well, and I do have a signed agreement from the other side that did mirror the authority that I was given. So I think I need to just explain that just a little bit further, what the terms of the settlement are. So just grant me a couple seconds. The REI matter was resolved, has been resolved. The total sum of the settlement is $916,571.96. Of that settlement amount, FORA will pay $694,000 directly to REI before dissolution. And FORA once that payment is made to REI and the check clears, the releases contained in the settlement agreement shall apply to FORA, the County of Monterey, the cities of Seaside, Marina, Delray Oaks, and Monterey. The remaining $222,571 of the settlement amount will be paid to REI in two separate alternative options. However, the parties to the agreement understand that Lafco will need to approve one of the two alternatives because Lafco is not a party to the settlement agreement. And REI is bearing the risk of having both alternatives rejected by Lafco. So the first alternative is that there is a certain amount of litigation reserve fund that may or may not be returned equally to the county and the cities of Marina, Seaside, Delray Oaks, and Monterey upon resolution of the litigation. FORA is going to grant Lafco the right to amend the indemnification agreement to assign the first $222,000 of the remainder of the litigation reserve fund to be dispersed first to REI, and then the remainder of the litigation reserve fund after the disbursement to REI shall be dispersed according to the terms of the indemnification agreement. Now, recall that this is all up to REI. REI may approve it or not approve it. And in alternative two, I'm sorry, Lafco, sorry. Alternative two, in lieu of alternative one, and as a compromise for REI receiving payment by September 1, 2020, FORA is granting Lafco the right to amend the indemnification agreement to assign an amount agreed upon by Lafco and REI less than $222,000 to be paid from the litigation reserve fund. The remaining money in the litigation reserve fund shall be held by Lafco and dispersed according to the terms of the indemnification agreement. So that is the settlement. The reason that we're doing it this way is because FORA and REI, because Lafco can't meet between now and the end of June 30th, the end of FORA, and this right that we're giving Lafco may or may not be accepted. So those are the essential terms of the agreement, probably more than what I needed to report, but I just wanted to get it out there since we're not having, I kind of anticipated in another meeting, we're not having one.
Yeah, we fooled you on that one. Thank you, Council. Appreciate you spelling that out. Okay, any other items from members? With that, then, we are adjourned. We are adjourning the last meeting of FORA.
Bye, everybody.
Bye-bye.
Bye-bye.
Bye.
We'll meet again.